You guys all set?
Yes, Your Honor. Thank you.
Recording in progress.
Court's going to call 24 CRI 001, State of Ohio versus Christopher Ferrell. Matter is before the court for a sentencing hearing. We are conducting that by remote video. Defendant's appearing from the Ashland County Jail. Mr. Ferrell, do you consent to having this hearing by video?
Yes, sir.
Defendant's attorney Gregory Tarkowski is also present. Prior to going on the record, I did afford the defendant the opportunity to speak privately with his attorney. On behalf of the state of Ohio is Ashland County Prosecuting Attorney Christopher Tennell. We are here today for sentencing. The defendant having previously entered pleas of guilty on April 12, 2024 to count 1, cruelty to a companion animal, a felony of the 5th degree, and count 2, unlawful possession of a dangerous ordinance, also a felony of the 5th degree. Mr. Tarkowski, is there any reason sentencing should not proceed?
No, Your Honor. Thank you.
Did you receive a copy of the pre-sentence investigation?
Yes, Your Honor.
Mr. Tennell, did the state receive that as well?
Yes, sir. Thank you.
Mr. Tarkowski, is there anything you'd like to say on behalf of your client?
Yes, Your Honor. Thank you. A little background on my client. He's 51. He's not married, does not have any juvenile children, was not previously employed at the time he was arrested on this incident. He did previously serve in the Marines, though. The PSI indicates he had an honorable discharge back in the early 2000s. He currently receives 30% disability that's connected to his service time. As far as this case itself, and speaking with my client, he does regret the actions in this case. He originally had a roommate who owned the cat that was, I guess, the victim in this case. Unfortunately, the roommate left, which resulted in my client kind of taking ownership of the cat. My client told me that the cat unfortunately had a kind of a poor disposition with him, as well as his other animals. He had a couple ferrets that he took care of, and the cat would attack him, would attack the ferrets and things like that. That ultimately led to him taking the actions, which are obviously regrettable in this situation. In retrospect, my client realizes that there were a number of other avenues he could have taken to get rid of the cat, much shorter than what happened in this case, and he certainly regrets what he did in this case. Subsequently, then in the search of his home, he did give a consent search to the home. He was cooperative with police officers with that respect. They found a sawed-off shotgun in his gun safe. Really had no kind of link to this case whatsoever. That just happened to be in his house. He also regrets having that firearm as well. As far as the PSI, I thought there were a number of favorable things from his perspective to outline. One is he had no prior felonies. He did have a prior misdemeanor history, but the PSI referenced that whenever he was placed on supervision in the past, that he had no issues on probation, that he was a good candidate on supervision and followed through with that successfully. The PSI noted he had an ORAS score of 13, which is classified as low. Also noted that he served 140 days to this point, which I think is fairly significant for a couple F5s. So in light of the fact that he has no prior felonies, that he's done well in supervision in the past, and he has a low ORAS score, we thought he was more than a great candidate for community control going forward. Thank you, Jeff.
Thank you, Mr. Tarkowski. Mr. Ferrell, is there anything you would like to say?
Yeah, it was all just an accident with the cat, sir. I mean, I only had driving privileges. I wanted to bury the cat properly, but I mean, I didn't want to take the chance of losing my license for driving after the time that I was only allowed to drive. Otherwise, I mean, there's really nothing else, Your Honor. I mean, it was strictly an accident with the cat.
Mr. Tennell, on behalf of the state.
Thank you, Your Honor. As we noted, I had the opportunity to review the PSI and would thank the court for that opportunity. I differ from defense counsel in my read of the PSI, as I see it as extremely problematic, quite frankly. And the defendant has rather unhelpfully to his cause here highlighted by his comments the state's problem with the case and the defendant in particular. The PSI notes a significant prior criminal history. And while there are no felonies, and we would acknowledge that, there are a lot of misdemeanor convictions. And really, that highlights what the state sees in the PSI in this case as continued criminal thinking on behalf of this defendant. Each one of those prior misdemeanor convictions represents an error in this defendant's judgment. And that leads right up to today. This defendant's really descent into this actually begins in the December 2023 case that's noted in the PSI for wrongful entrustment. The court will recall William Cahill from case 23 CRI 334, who the court recently sent to prison for assaulting a peace officer and felony 3 OVI. Now, I don't mean to put any of that on this defendant, but the car that Mr. Cahill was committing those offenses with is from this defendant, which resulted in the wrongful entrustment. So he gives his buddy the car that he knows isn't supposed to drive. And really, that's the investigation that caused the police officer to see the cat in Mr. Cahill's possession back in December. That when they are attempting to figure out whose cat this belongs to, that officer recalled that interaction and that cat because it all occurred behind the apartment. Today, and then in the PSI, the defendant refers to really both of the offenses before the court as accidental. That the gun went in his safe, it doesn't belong to him. He forgot it was there, is his comment. And yet it's obviously too short. It's not the only gun in the safe. So this defendant has firearms, has long guns, is presumably somewhat knowledgeable as to their use and keeping, and puts this dangerous ordinance into his safe for his buddy, which again is a compounding error in his criminal thinking. He then characterizes that as accidental. Oh, that thing, it's not really mine, it's just in my safe. In the PSI, he indicates that he accidentally stepped on the cat, which then led to his effort to bring about the cat's demise. And today it's the cat isn't that nice a cat and it's got problems. And so this is all an accident. And somehow because of the cat's disposition, he felt the need to do what he did, which is instructive. So let's examine what he did. He didn't accidentally stomp the cat with steel-toed boots. He repeatedly struck the cat by stomping on it. And when that didn't work and the cat wasn't dead, he attempted to shoot it with the pellet gun. Interestingly enough, he admits to causing the harm, tells the police that he stomped the cat intentionally, and then attempts to dupe this court by saying it's an accident now, but maintains that he didn't shoot the cat when that's really, there's nobody else to shoot the cat, and that's why they're in the gun safe, is looking, and here's the pellet gun that would correspond with the type of wound that the veterinarian saw during the necropsy. So this defendant wasn't even successful in managing to bring about the cat's demise. What he did and what he admitted to law enforcement as part of this is that the cat was still alive. He knew it was still alive when he put the cat, all of the cat toys and accoutrements that he had on hand, in an enclosed litter box, and then taped it shut and threw it away in the dumpster. The cat was located alive in the dumpster, but was so far gone by the time it received veterinary care that it had to be put down. There's nothing accidental about that. There isn't anything to say after he boot stomped the cat that he had some form of remorse to say, wow, this cat is now in bad shape, and to try to do something for it that would demonstrate that he has any respect for life. So this defendant's actions are beyond intentional. His attempts in the PSI and today to characterize them as accidental is a clear demonstration of a complete lack of understanding and a lack of remorse for why he is before this court. Now, as to the PSI findings directly, it is clear that the ORAS and the way ORAS is set up is not set up well for this particular offense. The object of this offense is a cat, okay? And the state understands that it's a cat, but the legislature has deemed it necessary to provide some protection for another living animal. And that doesn't come through clearly in an ORAS because the ORAS doesn't do well for sexual offenses, and it doesn't do well for this offense. If one were to look at the seriousness factors, the injury was worsened. The victim, the cat, did suffer serious injury. The defendant was in a position of trust as to this cat, and the relationship facilitated the offense. 4 seriousness factors that would move this from a low ORAS to at least a moderate. But recognizing that the ORAS, when it says victim, doesn't necessarily, I think, in the eye of the PSI writer, mean a cat. That's for a person. But the legislature has seen fit to provide protection and a duty upon us when one is left with the care of an animal to take some reasonable steps to care for that animal in a humane way. And this defendant not only failed to do that, he affirmatively violated that duty that's imposed upon all of us by law. These are a pair of F5s, but it's not one offense, it's 2 separate offenses in terms of criminal thinking. And so I think that it is entirely possible for this court to impose a separate sentence as to each count, to represent each individual error and lack of understanding by this defendant as to each specific count. The cruelty to animals count is defined as an offense of violence by the code. This is not a situation where the court's hands are tied and we have to impose community control sanctions. The court has the full width and breadth of sanctions from probation up to a maximum on the each felony offense. So ordinarily, with a lack of felony priors, the state would understand the defendant would be looking at perhaps a lower level prison sentence or perhaps even community control. Outside of the offense, which is appalling all on its own, the glaring lack of remorse and the glaring lack of understanding and the continued criminal thinking demonstrated by this defendant, even today at this hearing, in the state's opinion, would necessitate a moderate to high sentence with reference to prison sanction. And so the state would ask that this court sentence the defendant accordingly. Thank you, Your Honor.
Thank you, Mr. Snow. Court has received and reviewed that pre-sentence investigation. Counsel is correct. The ORS does come back as a 13, and which is low. Court's reviewed the case history, considered the statements of counsel and the defendant here today. Court has considered the purposes and principles of felony sentencing, including those set forth in 292911 and 292912 of the revised code, the relevant serious and recidivism factors, and the guidance with respect to this level of offense. Court has specifically considered the defendant's veteran status under 292912F. Court is required to look at all counts, regardless of how they come about separately, and determine the appropriate sentence for those counts separately. And I will do that here, starting with the cruelty to companion animals charge. I think Mr. Tennell, quite frankly, put it lightly, Mr. Ferrell. That pre-sentence investigation statement that you gave might be one of the most incredible ones I have ever seen. It's simply impossible to believe that this was an accident that occurred by you stepping on a cat in a dark room. And I say that because there are multiple factors that indicate that that's just the furthest thing from the truth. First, you told officers as much. You admitted to stomping on the cat and dumping it. First, you lied to them. You said that you took it out and dumped it at an Amish property. But then you eventually admitted that you injured the cat. You were hoping the dump truck would take it away. When you were asked to elaborate, you said it attacked you around 4 p.m. yesterday. You started kicking the cat with your steel-toed boots, knowing that it was severely injured and admitting to kicking it multiple times. You then put it in a litter box and put it in the trash. You were hoping the dump truck would take it in the morning and you would be rid of the cat. You were also aware that the cat was still alive the entire time, including when you placed it into the dumpster. Probably the most troubling statement you made to law enforcement, according to the PSI, was that you said you never shot it and never attempted to kill it humanely because you didn't care that the cat was suffering, because you didn't like the cat. When you were asked if you felt bad, you reiterated that you could have put it down humanely or given the cat away. You said no because you didn't like the cat. What also makes your claim that this was an accident not believable is the physical evidence, the injuries to the cat, excuse me. Cat had been, according to the vet, shot through the sternum, was badly bruised. There were bullet fragments in its hip. He had internal bleeding from the bullet, no broken bones. Small mark on his nose, which appeared to be a small impale hole, whether a bullet, pellet, or something else. It did not pierce his skull. He had severe hyperthermia. His paws were purple. His temperature was so low it wouldn't register on any thermometers in the clinic. The cat was struggling to breathe as its sinuses were full of blood and mucus. The veterinarians believed it would go into shock if they attempted to warm the cat. It was not stable enough to have surgery, and prior to being euthanized, it was barely conscious. Mr. Ferrell, I fully understand this is not a human life that we are talking about, but the court cannot overlook the seriousness of this offense. There's a depravity here that in these acts, it just stands out. And the fact that you seem to accept no responsibility for that is very troubling to the court. And looking at this offense and this type of offense, it would be hard to imagine a much more worse form of this offense than what you did to this cat. And looking at the second offense, as far as I'm concerned, if you brazenly lie that much in your pre-sentence investigation statement about the cat, it certainly calls into question any statements you made about the gun. And you claimed you didn't know it was in the safe. Regardless of whether if I believe that or not, it was certainly in your possession and under your control. The court would also note that you were convicted previously of aggravated menacing in a case that involved, as part of the resolution, a dismiss of the misuse of a firearm while intoxicated. So there is a past history of danger and violation of the gun regulations. The court is finding that the state is correct, that count one is listed as an offense of violence under 290101A9E. And the offense also involves having a firearm on or about your person or under your control with respect to count two. So therefore, I am finding that community control is not mandatory in this case. I'm finding that you're not a candidate for community control and that it would be demeaning to the seriousness of the offense. Court is further finding that prison terms are consistent with the purposes and principles of felony sentencing. As such, I am going to impose prison sentences. According to the law, unless the court is required to impose a particular sentence, the court should impose the shortest prison term authorized for the offense unless using minimum sanctions would not accomplish the overriding purposes of felony sentencing and not impose an unnecessary burden on state or local government resources. I am finding that the seriousness of count one justifies more than the minimum sentence. And in fact, I'm finding it to be one of the worst forms, if not the worst form of that offense. And the court is imposing the maximum potential prison term that I'm going to have available to me under that offense of 12 months in an appropriate penal institution. With respect to count two, unlawful possession of a dangerous ordinance, court is not making those same findings. Court is ordering that you serve the minimum 6-month prison sentence in count two with respect to the dangerous ordinance. Court is finding, however, that consecutive sentences are necessary to punish the offender and protect the public from future crime and not disproportionate to the seriousness of the conduct and danger posed by the defendant, and that two or more of these offenses are part of one or more course of conduct and the harm caused is so great or unusual that a single prison term would not adequately reflect the seriousness of your conduct. Therefore, the total aggregate sentence is 18 months in prison. Following your release from prison, you will be subject to an optional term of post-release control. It is optional in this case of up to 2 years. If you're placed on post-release control, you'll be supervised by the Adult Parole Authority. If you violate their rules, they may send you back to prison on a rules violation for up to 9 months at a time, but not to exceed 1/2 of your originally stated sentence for all violations. In addition, if you commit a new felony while you're on post-release control, the sentencing court for the new felony can terminate post-release control and impose a consecutive prison term to any prison term you receive in that case. It would be consecutive of 1 year, up to 1 year, or the time left on post-release control, whichever is greater. I am finding you to be a resident of Ashland County for purposes of post-release control. You do have 140 days of jail time credit as of today. You will continue to earn jail time credit until you're transported to the Ohio Department of Rehabilitation and Correction. You may be eligible to earn days of credit while you're there. However, those are not automatic. You must earn those through participation in educational, vocational, and other programs sanctioned by the Ohio Department of Rehabilitation and Corrections. Given the length of incarceration here and your ended status, the court is not going to assess fines. I am, however, finding that you have the ability to pay court costs in the future. I am assessing court costs to you. Mr. Tunnell, was there any restitution with respect to count one?
If I may have a moment, Your Honor. I might have a second, Your Honor.
Sure.
Sorry, Your Honor, I couldn't find that in my file. The Cat House Feline Sanctuary paid $1,000 for the vet bill out of this.
Mr. Tarkowski, would you like to be heard regarding restitution?
Yeah, I would just note none of those documents or bills have been submitted to Defense Counsel. Had the state wished to ask for that as part of restitution, that should have been forwarded to us well in advance, certainly prior to the sentencing hearing. They're also not part of the PSI or any other documents.
All right. I understand your lack of notice, Mr. Tarkowski. What I am required to do, though, I believe I have to order it today. If you object to it, you can file something. We can have a hearing on it. But for purposes of today, court is going to order $1,000 to the Cat House Feline Sanctuary for restitution with respect to count 1. Mr. Ferrell, you do have the right to appeal my decision. Any notice of appeal must be filed within 30 days of the sentencing entry. If you're unable to pay for the cost of the transcript or record or any relevant documents required for an appeal, those can be provided to you without cost if you are indigent. Likewise, if you are indigent and unable to obtain counsel, counsel can be appointed at no cost upon your request. Do you have any questions about your sentence, sir?
No, sir.
Mr. Tarkowski, anything further?
Yeah, just for the purposes of the record, I would just object to a maximum sentence with respect to count 1. Thank you.
That's fine. Mr. Tennell, anything further?
No, Your Honor, thank you.
Court is going to order the pre-sentence investigation be filed under seal in this matter. Any bond conditions will be released upon journalization of my judgment entry. Mr. Ferrell, you are remanded to the sheriff for transport to the Ohio Department of Rehabilitation and Correction. And this matter is adjourned. Thank you, gentlemen.
Recording stopped.